This presentation relates to securing digital or electronic evidence using mutual legal assistance, and will primarily focus in relation to the United States. And why? Because most of the major communication service providers are hosted there, and that's where you will garner the evidence in relation to corruption, money laundering, or other types of investigation with a transnational focus. So I'm talking about the Facebooks, Googles, Yahoos, Twitters, Microsofts of this world. So I want you to turn to your website, and on the menu you will see reference to cybercrime, and on the cybercrime page you will see presentations, and the last presentation is entitled International Inquiries. And if you open that, and you'll see a PowerPoint presentation. So it's entitled Comms Data LOR, an introduction. So comms data, communications data. So the data held by the communication service providers. LOR, letter of request, otherwise known as a formal mutual legal assistance request, in French, commission rogatoire. So if we go to the next slide, the process is incredibly slow. Many of you may well recognize that it takes a long time to secure evidence from another jurisdiction. There are a number of reasons for this. One is that there is a poor interaction between investigators and state attorneys, or those who have to send the request. So it may well be that investigators know what they want, they may well draft the letter of request, and then they process that, send that to the state attorney, who may just rubber stamp it, or there has been some confusion about what is actually requested or the standards that are needed in the other jurisdiction to be able to garner that evidence. In short, the investigator and the prosecutor should be working together to determine exactly what is needed. The delays come into the system when there is a failure to understand the requirements in the other jurisdiction, be it dual criminality, be it in terms of the process and procedure to garner that evidence, and the standards required to get that executive action, that search warrant. What do I need to establish? What do I put in my letter of request? And equally, the letter of request not containing the relevant information. So the central authority in the receiving state will want to know the relevant information they need to put in their application to secure the evidence. Very important, therefore, that we have some working knowledge of what is needed in the other state. We need to be proactive. As attorneys, prosecutors, pick up the phone and find out. Don't just send the request and hope to receive the evidence in due course, because you'll only be disappointed. It's the same as when you apply for any process in your own country, you're going to have to understand the law and the relevant material that I put in there. You're not going to put material that the judge will say, well, actually, I don't need that material, or anger the judge because you put irrelevant material in there. Keep it focused, keep it relevant, keep it to the material that is needed. But that does need an understanding. So with that in mind, I have produced, and you'll see on page 3, this was for our own Crown Prosecution Service, a guide to the collection of evidence from the United States. And due to that being a successful model, the United Nations asked if they could have a guide that would fit for other jurisdictions. So with that in mind, if you go to your website, and again on the cybercrime page, down the bottom, you'll have guides, And if you click on the Communication Service Provider Guide, there is a guide that has been prepared after I have spoken to the relevant communication service providers, worked with the Department of Justice in the United States, so I know the applicable standards to secure the relevant evidence. And I'll just take you on a whistle-stop tour in relation to the main contents for the guide. So I hope it will be useful in order to confirm preservation, informal assistance and evidence through mutual legal assistance. And this is what I call, on page 4 of the slides, this is what I call PIE. P-I-E. Preservation P, informal assistance I, evidence E. And the guide will have reference on page 7 to the law enforcement guidelines for most of the major providers in the US. And equally then it goes through chapters on preservation and then informal assistance and the standards required in relation to securing any content data. And that is very important because you will need to know the different, on slide 5, legal standards. So, I want to go back to the guide, and in relation to preservation, I have put as much detail as I can in relation to the major CSPs, the communication service providers. So page 13, you can see Apple and what they require. The 90 days is critical, and the 90 days is very much a legal basis under the Electronic Communications Privacy Act. 90 days maximum. There can be an extension to 180 days, but that requires an application to extend before the expiry of the first 90 days. Remembering, if you don't preserve, the data goes. So you must always preserve. Indeed, if you don't preserve, your letter of request for formal evidence will not be executed. If the Department of Justice cannot see you have preserved, they will say, well, it's a waste of our time because how do we know the evidence is there? And on that basis, they will not execute. So you must always preserve. Now, obviously, under Section 100 of your Electronic Transactions Act, you have the power for a law enforcement letter to be sent to preserve for up to 14 days. Then under Section 104, there is also the process to secure a court order. You must be in communication with the US communication service providers to confirm what they will require from you. But you can see Apple, it's a signed letter served by fax or email. So if you send what they want, then they will preserve for that period of time. So you're going to have to think about the difference between your domestic law and the process in the United States. So your domestic law would only allow you to preserve for 14 days and then Section 104, a court order. You will have to confirm with the providers what they need from you. Do they need that court order or do they just need their own process? My experience is they will only need their own process. In short, that means Section 104 is only applicable and Section 100 to your domestic providers. But you must be in contact with the providers in the other jurisdiction, no matter where they are in terms of the process that they will require. So you can see Facebook has a different process, and this is the difficulty in relation to each provider. They all have different rules and processes and regulations. So I hope this will assist in relation to exactly what is needed. Now, equally under your domestic legislation, the user will not be notified. Now, the present system for international requests is that the provider in the US will not notify a user, but that could be subject to change. equally think as to whether the US provider may then suspend or delete the account. So then the bad actors are going to know something has happened. So again, you may want to find out what happens from the provider when you do ask for preservation. Is the account shut down? Because if that's the case and you have a covert investigation, you may well be alerting the suspect or the subject in relation to law enforcement interest. Informal assistance, very, very important. Because of the inherent delays in relation to mutual legal assistance, is there anything that you can do informally? Very, very important. I'm going to move on to emergency requests and urgent later in this presentation, but I just wanted to look at other types of informal assistance by voluntary disclosure from the communication service providers themselves or by way of consent. So when we're talking about informal use, this isn't for intelligence purposes, this is for you to use evidentially. Now, with basic subscriber information and in some cases transactional metadata or traffic, you may well be able to secure this material directly from the major US CSPs. So basic subscriber information: who has the account, who opened the account, when did they open the account, and where did they open it from, the internet protocol address, where was it opened from. This may be all critical information that you may assist your investigation and your prosecution. And then the transactional or traffic or metadata. So in other words, the evidence that shows who sent a message, where it was sent from, who it was sent to, and when. Very important material that may again assist your investigation and prosecution. Is there a way to be able to garner that without having to send a mutual legal assistance request or a letter of request? Well, some providers will provide it directly. And again, you will have from page 23, you will have the different providers and what they may provide to you directly. Now, you're going to have to find out from each provider what they will provide. I provided a list there of what they have said in the past. Is that still up to date? You should contact them to confirm what can be provided. And equally in what format they would need confirmation. They may need reciprocity. So this is a fundamental concept of mutual legal assistance. So if I'm the United States and I have the power, do you also have the power in Ghana? So if the situation was reversed, if I'm the United States contacting Ghana, do you have the same power to be able to produce the material as you're requesting from me? Now you do have provision. If we look at your cybercrime guide. Now if we look at your investigative tools, at page okay, we are at page 30. If we look at page 35, apologies, page 35, section 102, there is provision for an electronic communication service provider to disclose information. And that would be under subsection 2, on receipt of a court order for the disclosure or on the written consent of the subscriber or customer. So if you have a court order, can you provide that court order for the traffic, the metadata, the transactional information directly to the US communication service provider without having to send a letter of request? Now, I have put that within the commentary on page 35 of the Cybercrime Guide. You're going to have to confirm with the provider whether you can do that. It requires somebody, an investigator, a prosecutor, to pick up the phone and discuss with them. They also may have a second stage, which would be in relation to ensuring the safeguarding of the suspect's accused rights. So they will not provide that informally, that traffic data, that metadata, if the death penalty is involved. So you're going to have to conform to whatever their process is to be able to supply that information. They may not supply it, but isn't it worth asking the question to secure that type of material quickly? Definitely check whether you can garner that material on the basis of a court order obtained domestically in Ghana, but then you will serve on the communication service provider to obtain that material directly from them. Now, can you secure a statement from the provider as well? Some will, some won't. Facebook will not provide a statement informally, but others might. Google certainly may do that, but you're going to have to ask, and you're going to have to provide them the format, or they may just put it in their own format. If that contains hearsay, you're going to have to be then considering whether that is admissible. And if it's not admissible, then Section 72 and Section 73 of the Mutual Legal Assistance Act will allow you to go and secure that evidence. It would be then formally through a letter of request, and then the hearsay would be admissible. So again, this is why investigators, prosecutors working closely together to determine which is the quickest route to be able to secure this material. There are also other routes in relation to securing evidence that is quicker than sending a letter of request, and this may be via consent. So if you look at page 21 of the guide, that there may be processes where, and equally this is reflected in section 102 of the ETA in Ghana, that if the user consents, then there are processes by which you can secure using the CSPs themselves. So, for example, Facebook on page 22, there is a download your information process, but remembering that this will be the user themselves. So obviously if you have a suspect, they're unlikely to download their information. They may do, and it may be a tactic at the start of any interview to ask them to sign a consent form. Then you're complying with section 102, and it may well be that the provider will allow that information to be accessed. It's unlikely in every situation that all providers on the receipt of a consent authority will then provide the information. You may well have to use their own facilities that are available on their own websites. So, for example, the Facebook download your information. There's another one for Google Takeout, another one for Twitter that's on page 22 of the guide. But others, such as Apple, Twitter and AOL, may provide. But again, Apple has some differences there as well. But I've detailed those within page 23 of the Communication Service Provider Guide. But you can see not every process is the same, and this is why it sometimes can be difficult. But don't make it so that it is too difficult. The information will always be there. Somebody can always provide the answer for you, even if it's not included within the guide. Equally, think about witnesses, because it may be that you don't need the consent to use Google Takeout or the Facebook download your information from the suspect. It may be that there are witnesses who will be able to provide the same information because messages were sent to them. So think about what would be the quickest way to secure the evidence that you need, and whether it would be admissible if you do go down that quicker route. Now, I also wanted to outline in relation to evidence through mutual legal assistance. So there are different evidential standards in relation to whether you're applying for basic subscriber, transactional or content, or real-time interception. You can never get real-time interception of content, but you can in terms of traffic. So within the guide from page 35, there are the evidential standards, which will be less for basic subscriber evidence. So that's only relevant and related. And then for traffic, it will be specific facts which are relevant and related and material to a criminal investigation. So please study the guide for the different standards. Why? Because this is what you need to satisfy when you write your letter of request. You need to provide the relevant factual circumstances, not everything carte blanche, because that's why letters of request get knocked back. You need to include what is relevant to establish relevant and material to a criminal investigation for traffic, or the much higher standard for content, the content of the message sent between two parties in an email or a message, probable cause. And probable cause is a very high standard. And probable cause may create difficulties in order to secure the content that you need. So again, be realistic. If you cannot establish probable cause, which in short is, you know what is in the message, and that relates to the criminal offence. You know that, the message will contain the evidence that relates to the criminal offence. If you cannot satisfy that, be realistic and just go after the traffic, because that may assist your investigation in terms of when a message was sent, where it was sent to, and when. Remembering that telephone billing is often the same, that will only tell you when a call was made, who received it, the duration, and when it was sent, and maybe where through cell site. So you may not have the intercepted conversation on the telephone, but you'll have the billing. The metadata, the traffic would be much the same. So be realistic. And that's why you should always send a draft to the Americans before. Send the draft so they know in terms of whether you have met the standard of probable cause, because you don't want to wait and have it executed only then for a judge to say no. In fact, the US will not prepare if probable cause hasn't been satisfied. So top end that. Find out straight away. Phone them up and determine whether you can establish probable cause with the information that you have. Another major reason for knocking back in relation to letters of request is attribution. So this is page 6, slide 6 of the PowerPoint presentation. So who controls? Who is the user in relation to an account? Is that the person who's involved in the criminality? How do you attribute what is contained in the message to the suspect? And how is that linked to the criminality? That is one of the main reasons why often letters of request are not executed, because it's just speculation. We don't know who the account belongs to, but there's some criminality. They've got a Facebook account, so there must be some criminality there, because we believe there's criminality in relation to their Google email. You have to confirm the evidential standard, the attribution for each separate account. It's as if you're applying for a search warrant for each property and you know there's relevant evidence within the property. Treat social media and email accounts separately and providing the relevant standard of legal information. Now, within the guide, I have provided a checklist and also a precedent letter of request. And within that precedent letter of request, you will find from page 60 the standards that are required and also what each provider will provide. So from page 69, you will see what Apple will provide, and then I've done it for all of the other providers in terms of the specific information that they will provide. So please, you can use this as a catalogue to determine the information that you request. Now, there is provision when you're doing any mutual legal assistance request to maintain confidentiality. There may be material that is included that is sensitive and you don't want disclosed to another party. Very important that you include that within the letter of request. Do you want the material that is sensitive to be sealed? Do you want the letter of request to remain confidential? If that's the case, you will have to put a request and justify why the material should be sealed. Is there an ongoing investigation, and to disclose the information could prejudice that investigation? Justify relevant material. Please note that your letter of request or the information therein will only be sealed or remain confidential for 2 years. You may not receive notification, and you will then have to justify why it should be further sealed, which may be difficult if your letter of request has been executed and then there has been a trial. And don't just be putting sealing request or confidentiality request as norm, because you always want to justify. If the evidence is in the public arena, there's no need to seal. If the suspect has already been questioned about evidence that you're seeking to now secure evidentially, then you don't need to seal the letter of request. Be realistic. Moving on to slide 8. Urgent requests. Now this, of course, is increasingly important in terms of cyber attacks, whether they be DDoS attacks or there might be cyber attacks on critical infrastructure. Please use the emergency provisions that are available. So if we turn to page 20 in relation to this cybercrime guide, the CSP guide. Also, please be aware that you will have the emergency provisions that are detailed from page 38 of your Ghana cyber guide. But if we look at the communication service provider guide, there are circumstances, and this is from page 20, that you can directly go to communication service provider under the law of the United States, the Electronic Communications Privacy Act, if there is an emergency involving immediate danger of death or serious physical injury to any person. Hypothetical possibilities will not satisfy, and the danger requires disclosure of information without delay. So the communication service providers will always look at immediacy, always consider, is there an imminent danger of death or has that time passed? So it could be, for example, that there is a kidnapped situation, but the individual has been released and you're trying to locate the kidnapper. The communication service provider may well say, well, there's not an emergency anymore because the person kidnapped has been released and you're only trying to locate the individual concerned. It may be you can satisfy they have a gun on them and we have credible intelligence that they will use that on another individual or a targeted person that you know about. But the former may be a hypothetical possibility. They may well use the gun. You're going to have to be specific, and they are tough, the major CSPs, on satisfying this because of the breach of privacy of data. Secondly, the danger requires disclosure of information without delay. What information do you need? Do you need to locate them? Is it just the IP address in relation to a message? Is that going to satisfy you in terms of what you want? What do you want? You want to locate, so the IP address is enough. You don't need to know the content of any message. Or is there a reason to know the content because a threat is being made and that may locate where the offender is or where they're going to? So you're going to have to be relevant and tailoring exactly what you need specifically to the facts of your situation. Now, in terms of the process, often you'll need to do that through the legal attaché at your US embassy in Accra. So you would contact the legal attaché who will seek to verify the information, and then they may well contact the CSP. But in all circumstances, the legal attaché should be contacted. So in emergency situations, please have a process where you can contact without delay in relation to that legal attaché to then contact the providers. Exceedingly important. Please be aware that some providers still may not provide that information. They may say, we don't know about it. There may be a small provider in the US, or they may say, no, we want a formal request to be sent through. In that case, you're going to have to send an urgent letter of request. you're going to have to do it quickly. And I hope that the precedent in your guide, the guide for cybercrime in Ghana, and also what I've included within this guide, you can cut and paste and use. That's what it's there for. So please use the material and the tools that are available. But remember, emergency, DDoS attack, attack to critical infrastructure, terrorist bombing, what is the threat of immediate danger, of serious physical injury or death, and what is the information you need, and why is that needed without delay. Moving on to slide 9, freedom of speech. Now, the US law on freedom of speech, the First Amendment, is extremely wide-ranging. So please consider that in relation to any material you may need in relation to slander, criminal libel, or any harassment cases, or cyber stalking, or equivalent cases, threats to kill. Please consider this, because freedom of speech is very wide-ranging. The Office for International Affairs, the central authority in the US, they have a committee that will consider all freedom of speech cases. So there may be an issue in relation to prosecuting journalists or using journalistic evidence. Please consider this when you are sending a letter of request. I cannot emphasize enough, have direct contact with the US and confirming whether, if there is a freedom of speech issue, what the likely lay of the land is in terms of whether the committee will process this. You don't want to waste your time. So you may be thinking, well, do we continue to prosecute, or is there another way to garner the information? Could we go directly to the communication service provider, but equally, will they consider freedom of speech issues? So please consider this on each and every occasion. Top end your investigations, working together, prosecutors, investigators, but liaising with the overseas authority as well. Slide 10, the future. In essence, it's not really the future. I want to talk about encryption. Encryption is here. It's, of course, important to have encryption. We have a lot of private data that's available on our computers and in the cloud. And very important that that is protected. Saying that is, we want to protect our family and personal belongings, we lock our doors, we lock our cars. And why? Because we want to protect it. Encryption is much the same. There is also end-to-end encryption. So if a message is sent by me from my mobile phone using WhatsApp, for example, it's scrambled, the message, when it leaves me. And even if somebody was to intercept before it's received by the next party, it will be in jumbled letters. Maybe there might be a way of breaking that code, but it's unique for every provider. So therefore, it could take time to unscramble. But once it's received by the next party, again, it's in a scrambled format. Can that be deciphered? And then again, some providers will delete that message as soon as it's opened. So sometimes the only way to secure the message is by having the device itself. But then, of course, there may be a PIN code to this device as well. So how do I get into that? This is where the cloud may assist. And the cloud may harness that information. So Apple, for example, has an automatic backup which would allow you, via letter of request, to secure the content for encrypted messages. So consider whether you can obtain that information from Apple. You're going to have to preserve. And then when you're preserving, Apple may tell you the size of the preservation with the date range. And then that may give an indication of the type of information that's stored there. But you're going to have to be specific in relation to the type of information that you require when you send your letter of request over. So even if there is encryption, there may be material in the cloud, and other providers have clouds as well. If you know that the backup has gone to that cloud, then consider that as a way to go and get the content. But sometimes you don't need the content. Sometimes you just need where a message was sent to. when it was sent, and where from. Much as we were talking about the telephone billing, often that is the critical evidence to show where somebody was located at a relevant time for the criminality, who they sent it to, which is a third party known to be involved in the criminality. So always think about what is the relevant material that you want. If it's just the metadata, the traffic, the transactional, then you can send a letter of request for that from WhatsApp. WhatsApp will not provide that informally, but you send a letter of request. Once you've preserved the material, then they will have to disclose it via a court order. So please always think about, well, there's encryption. That doesn't mean the end of the pursuit of the evidence. There may often be another way. And that's why it's important on slide 11 to contact, to ask, to work together, to find somebody who does know the answer. International inquiries can be slow. International inquiries for digital evidence can be complex. But in many instances, as long as you're focused and you're asking for the right type of evidence, you're thinking of the admissibility, you know the standards in the other jurisdiction, and there are experts who will be able to provide that information to you. There are the tools with the guide to cybercrime and also the communication service provider evidence, then that will greatly assist you. And I hope those tools will equip you with some knowledge to be able to assist your international inquiries.